A federal judge has just permanently blocked the release of special counsel Jack Smith's report on President Trump's classified documents case. And that means Attorney General Pam Bondi and any attorney general after her cannot release or share the second volume of Smith's report. Let's bring in CBS News Justice correspondent Scott McFarland. Scott, good to see you today. So what reason did the judge give for blocking this portion of the report?
It was a lengthy opinion. Among the things Judge Eileen Cannon cited was the fact that there was nobody convicted in connection with that classified records case, a case she dismissed in July 2024 against then former President Trump, but also that the records are to be sealed to protect the reputations and potential future legal exposure of Trump's co-defendants in that case, his former aide Walt Nauta included. This is the latest victory Judge Eileen Cannon has handed Trump. She, of course, dismissed the classified records case, as I mentioned, in July 2024. She also slowed down that case.
All right, people, Dr. John here. So what is happening right now? Legal experts across the board are using the same word, inevitable, not probable. Inevitable. A piece of evidence prosecutors have been chasing for years just surfaced, and it's so thoroughly documented, so precisely time-stamped, that defense attorneys reportedly have no answer for it. Now, before you roll your eyes and think, here we go again, another supposedly career-ending revelation that'll fade by next Thursday, I need you to understand why this moment is fundamentally different.
Prohibitively over the 2 years it was in existence by ruling in favor of Trump and ruling in favor of delays to push that trial date beyond the 2024 election. This, though, is also a defeat for people who just want to see what Jack Smith, the special counsel, found in this profoundly important and unprecedented case where he accused a former president of unlawfully keeping classified records at a private resort in Florida.
And Scott, I also want to ask you about this because there was an armed man who was shot and killed after an authorized entry into Mar-a-Lago. What can you tell us about that?
Speaking of Mar-a-Lago, the U.S. Secret Service and local law enforcement in Florida say they shot and killed a man who had breached Mar-a-Lago yesterday morning. President wasn't there, but it's a secure place. And the man who breached, Austin Martin, allegedly had a shotgun and a canister of fuel with him and disregarded police orders to put the gun down. That's according to law enforcement. Martin was shot and killed, and the investigation's ongoing, but we'll underscore, the president wasn't there, first family wasn't there. There were no Secret Service protectees at Mar-a-Lago at the time of this breach.
I've covered politics and legal drama for years. I've watched the hype cycles come and go. I've seen pundits scream about smoking guns that turned out to be water pistols. This is not that. What landed on the court docket recently has completely reshaped the legal battlefield. We're not dealing with leaked rumors or anonymous sources or some disgruntled former employee with an axe to grind. We're talking about official government documentation, Secret Service records, communications that were logged, time-stamped, authenticated, and preserved.
Breaking overnight, the new legal fight that Donald Trump is taking on just days before he takes office. The president-elect is now trying to stop special counsel Jack Smith from publicly releasing his final report on his investigations into the president-elect and the two federal cases that were brought and dismissed. Why is Donald Trump fighting this now? His lawyers read a draft of that report and argue in a new court filing it contains, quote, baseless attacks, which they call an obvious effort to interfere with upcoming confirmation hearings. So this only adds to the mounting intrigue, of course, around this report and its potentially imminent release. Let's get over to Caitlin Poland. She's got much more of this for us. Caitlin, walk us through this. What do we know about the report, and when can we see this?
Specifically because they were always going to matter in a courtroom someday. That day has arrived. And here's what makes this so wild. The entire foundation of the defense strategy just crumbled. For years, the argument has been consistent. Nobody saw it coming. Everything was spontaneous. There was no plan, no coordination, no foreknowledge. That has been the mantra repeated in court filings, press conferences, and cable news hits.
Yeah, Kate, we've seen reports like this before from special counsel's offices, but not a fight like this on whether it could be released from the Justice Department. So what we can gather from court filings so far is that in these two cases against Donald Trump, the Attorney General is going to be reviewing a 2-volume report, one very likely about the classified documents case that was before Judge Eileen Cannon in Florida, and then another volume about the January 6th case against Donald Trump. What is happening in those volumes, we haven't seen them, but Trump's lawyers and others have been able to review them behind closed doors, is that they are the summations of these cases, these summations of the investigations. What the special counsel's office says is that they are not going to be handing their finalized report over to the Attorney General until at least 1 p.m. today. And if the public sees it.
But according to what prosecutors just submitted, that narrative isn't just wrong. It's the complete opposite of what actually happened. The new evidence allegedly shows detailed discussions, step-by-step planning, and explicit awareness of exactly what could unfold. Not vague concerns, not hypothetical worries. Concrete, specific conversations about potential violence, documented in real time by the very agencies tasked with keeping everyone safe.
It won't be out until at least the morning of Friday, but ultimately it's up to the Attorney General, and the Attorney General hasn't decided yet if that report is going to be public. Now, Trump's lawyers did write to the Attorney General on January 6th, yesterday, saying that he's got to get rid of Smith and not release this report. He said that part of this is about presidential immunity, that Donald Trump should face no criminal process, including disclosures about a prosecution around him while he is the president-elect. We'll see if that argument holds in court with Judge Cannon, too, which is where Trump's lawyers are now arguing to her, stop this, don't let them release it to the public.
Let's add another layer to this, Caitlin, because there are two men associated with Donald Trump also named in this, also with, let's say, a very vested interest in it. What do we know?
Think about the significance of that. The people whose entire job is to anticipate threats were communicating about those threats with Trump's inner circle. And those communications were written down, recorded, preserved. You can't memory hole a Secret Service log. You can't delete an audio memo that's already in federal custody. This evidence has a permanence that witness testimony simply doesn't. And that's why legal experts are practically tripping over themselves to declare this the end of the road.
Yeah, Kate, that's where this is complicated a little bit more than in other special counsel's cases, because you have these two cases, criminal cases in federal court against Donald Trump that are dismissed, but there's an ongoing case, part of that classified documents case, the obstruction portion of it, against his two co-defendants in Florida, Walt Nauta and Carlos de Oliveira, two men who worked for Trump personally. And so because there are appeals over their case, and they could continue to face those court proceedings, even the prosecution, the lawyers for Trump and their lawyers are saying, you can't make statements about them publicly in a report. Here's a quote from the filing. The final report is meant to serve as a government verdict against the defendants. The report revealed a one-sided narrative. There remains the threat of future criminal proceedings as to Nauta and de Oliveira, those two co-defendants, and those proceedings will be irreversibly and irredeemably prejudiced. That's what the position is from the defense side, arguing to the Attorney General. Don't release it, Justice Department. Do not put things out about these guys.
Let me introduce you to what some of the sharpest legal minds in the country are saying, because their reactions tell you everything you need to know. Glenn Kirshner, former federal prosecutor with decades of experience putting criminals behind bars, went on MSNBC and didn't hedge, didn't qualify, didn't offer lawyerly caveats. He said conviction is now virtually inevitable if this reaches a jury. Those aren't the words of someone trying to generate clicks.
See what happens. Great to see you, Caitlin. Thank you so much for laying it all out for us. Really appreciate it.
CNN senior legal analyst Ellie Honig is with us now. Good morning, counselor. Talk to us about exactly what this final report from a special counsel is, what role it plays in special counsel investigations, and whether we're actually going to see it in a few days.
So, John, if we think back a few years ago to the Robert Mueller report, that's essentially what this would be. The special counsel regulations under which Jack Smith is operating say that at the end of his investigation, and we're there for Jack Smith, he must, it's mandatory, create a written report that lays out his findings. Now, at that point, the report goes to the Attorney General, who then may, not must, but may release it to the public. Now, Merrick Garland, so far in his term, has immediately released special counsel reports to the public. He did that with the Robert Hur report about Joe Biden's classified documents. He did it with John Durham's report. So Donald Trump is taking really an unprecedented step here of trying to block the release of that report. Every time thus far in our recent history where one of these reports has been written, it has in fact gone over to Congress and then come out to the American public.
There are a couple interesting legal nuances here when it comes to the classified documents case. Number one, Judge Eileen Cannon basically threw out this case because she ruled the appointment of a special counsel was unconstitutional on its face. So could that impact the existence of a report?
That's a seasoned prosecutor who understands exactly what moves juries and exactly how devastating certain types of evidence can be. When someone like that drops the word inevitable, the legal world pays attention, and he's not alone in this assessment. Over on social media, constitutional scholars like Lawrence Tribe and ethics experts like Norm Eisen have been analyzing these developments in real time, and their conclusions are remarkably aligned. They're talking about how this could fundamentally alter the political landscape.
Yeah, that's a fascinating question. I think that'll be the argument that Donald Trump will make to Judge Cannon. But remember, she only has the classified documents case. There's a separate case in Washington, D.C. on the January 6th indictment. So that argument's not going to apply. But I do think he's going to argue, Donald Trump's team will argue, the entire institution of special counsel is unconstitutional, as Judge Cannon found, and therefore you cannot release this report. That will take us into unknown territory, because while there have been several challenges lodged against special counsel over the years in various cases, not just this one, they've all failed up until Judge Cannon. So that could be the hook that he's trying to use here.
And one other little nuance here is that there are two other people charged and still charged in this case, Walt Nauta and Carlos de Oliveira, and their lawyers basically arguing, look, you put out this report, this could prejudice the case against them.
How it might shift undecided voters who've been sitting on the fence, how it could establish legal precedents that reshape presidential accountability for generations. We've officially moved past the question of whether this is serious and entered the territory of what happens when a sitting president faces evidence that multiple federal prosecutors would call a guaranteed conviction.
It's such an interesting wrinkle because they have a much stronger argument than Donald Trump does, because Donald Trump is out of this case. It's been dismissed against him. So the argument to him is you don't have any real stake in what comes out in this report. But Nauta and de Oliveira, those are the two Mar-a-Lago employees who were charged along with Trump in the classified documents case. They are still defendants, and they will say it wildly prejudices us and undermines our rights to have this long written tome come out that will talk about all the criminality we've engaged in. Now, on the flip side of that, I would bet you, John Berman, that by January 21st of this year, both Nauta and de Oliveira are recipients of pardons, but the report's got to come first, so we'll see.
That's a very fair point. Look, one of Donald Trump's best friends over the last several years has been the clock, right? So how does the clock play here? If this report isn't released, if it's held up even days, could he somehow keep it from being released once he's president?
But here's where I need to get real with you about the political dimensions of this, because they're absolutely insane. We're watching this unfold while Trump occupies the White House. Let that sink in for a moment. A sitting president is facing federal criminal charges backed by evidence that career prosecutors are calling ironclad. The optics of this are unprecedented in American history. We have never, not once,
Absolutely. He's got a very distinct line in the sand, noon January 20th. When he takes that oath of office, he will then be in position to install his own attorney general, whether Pam Bondi has been confirmed by then or not. But he can take charge of DOJ and say, do not issue this report. So we are very much on the clock here. Donald Trump is trying, again, to draw things out. But if he can keep this thing locked up in the courts until noon on January 20th, then when he becomes president, he very much will be in position to kill this report and make sure it does not come out.
All right. It will be a very interesting, 12 days on this front. Ellie Hogan, I don't think I'm speaking out of school by saying you're actually writing a book on special counsel, so this is an area you know quite a bit about. Looking forward to that read.
Been in a situation where the person currently running the country is simultaneously fighting a criminal case with this level of documentation arrayed against them? Depending on your political perspective, you're either watching justice finally catch up to someone who's evaded accountability for decades, or you're witnessing the most brazen weaponization of the legal system ever conceived. There's almost nobody in the middle. That's the reality we're living in. Two completely different interpretations of the same set of facts, and absolutely no bridge between them. And the timing makes it even more combustible. Public trust in the Department of Justice has been eroding for years, with recent polling showing confidence levels scraping historic lows. Huge swaths of the population already believe the system is rigged, that prosecutions are politically motivated, that the powerful get different treatment than everyone else. Dropping this evidence right now doesn't just pour gasoline on that fire, it detonates the entire gas station. If you believe Trump has been unfairly targeted, this looks like the deep state making its final desperate move. If you believe he's been skating on thin ice for years, this looks like the reckoning that was always coming. Neither side is going to convince the other. Both sides will see exactly what they expected to see. And that means whatever happens in court, the social and political damage is already done. The division, the distrust, the sense that we're living in parallel realities with no shared foundation of truth, that's baked in now. Irreversible. Now let's get into the actual substance of what prosecutors have submitted, because the details are where this gets truly devastating for the defense. The Secret Service component cannot be overstated. These aren't text messages between junior staffers that could be misinterpreted or taken out of context. The Secret Service operates with meticulous documentation protocols, specifically because they know their records might need to stand up in court someday. Every communication is logged, every decision is documented, every security assessment is preserved with timestamps and authentication chains that make them virtually impossible to challenge on evidentiary grounds. When prosecutors say they have Secret Service communications showing coordination and foreknowledge, they're holding official federal law enforcement records, not speculation, not hearsay, not someone's recollection of a conversation from 3 years ago. These documents were created contemporaneously by people whose professional credibility depends on accuracy. Juries understand this intuitively. They know the difference between a witness trying to remember what happened and an official record created at the moment things were happening. One requires trust in human memory. The other just requires you to read. But the Secret Service logs are only part of what's been submitted. According to reporting from major outlets like the New York Times and Politico, prosecutors have also assembled email chains and audio memos that allegedly show detailed planning discussions happening in the days leading up to January 6th. We're not talking about vague references or passing comments. We're talking about specific conversations about security arrangements, about who would be where, about what the crowd dynamics might look like, and critically, about the potential for things to get out of hand. The word potential might seem soft, but in a criminal context, it's anything but. If you're aware of a potential for violence and you proceed anyway without taking reasonable steps to prevent it, that's not negligence. That's something far more serious from a legal standpoint. It goes directly to state of mind. It establishes that you weren't caught off guard. You weren't surprised by how things unfolded. You considered the possibility and moved forward regardless. This is where the spontaneous chaos defense completely falls apart. Defense attorneys have spent years building a narrative that January 6th was unpredictable, that nobody could have anticipated what happened, that it was just a rally that got carried away. But if internal communications show people actively discussing the possibility of violence beforehand, that narrative becomes impossible to sustain. You can't claim you were blindsided when there's a paper trail showing you talked about exactly what might happen. A jury doesn't need to be legal experts to understand that contradiction. Normal people, everyday citizens who get summoned for jury duty, they understand that if you discuss a risk and then do nothing to mitigate it, you bear responsibility for what follows. That's not some complex legal doctrine. That's basic common sense. And common sense in a courtroom is often more powerful than the most sophisticated legal argument. The audio memos deserve special attention because they're the kind of evidence that prosecutors dream about. Recordings of actual voices have an emotional impact that documents simply can't match. When jurors hear someone's tone, their inflection, whether they sound concerned or dismissive, whether they're rushing or being deliberate, it creates an impression that transcends the literal words being spoken. If these memos capture discussions where people sound like they understand the gravity of the situation, where they acknowledge risks in their own voices, where they debate how to proceed knowing what they know, that's devastating. You can argue with a transcript. You can claim words on a page are being taken out of context. It's much harder to argue with a recording where someone's own voice betrays their awareness. Prosecutors know this. They build cases around recordings whenever they can get them. And if they've got audio memos from within Trump's orbit discussing security concerns before January 6th, that's the kind of evidence that makes defense lawyers lose sleep. The emails add another layer entirely. Unlike a single conversation that might be misremembered or disputed, email chains show the evolution of thinking over time. They show who was looped in, who responded, what decisions were made, and when those decisions were made. They establish a timeline that's almost impossible to refute. If prosecutors can walk a jury through a sequence of emails showing the awareness of potential violence growing, the discussions becoming more urgent, and then the ultimate decision to proceed with the rally as planned, that paints a picture of deliberate choice rather than accidental oversight. That's the difference between a case built on inference and a case built on documentation. Inference asks jurors to connect dots. Documentation shows them the dots already connected. It removes the burden of interpretation and replaces it with the simple act of observing what's already there. Legal analyst commentary has been remarkably consistent on this point. The phrase direct evidence keeps coming up, and in criminal law, that distinction matters enormously. Direct evidence doesn't require jurors to make assumptions or draw conclusions. It speaks for itself. A witness saying, "I saw him do it," is direct evidence. A security log showing who authorized what is direct evidence. A recording of someone acknowledging a risk is direct evidence. Circumstantial evidence, by contrast, requires an inferential step. It says this happened and that happened, so you should conclude this other thing probably happened too. Circumstantial cases can be strong, but they always leave room for alternative explanations. Direct evidence closes those escape hatches. When you've got records instead of recollections, documentation instead of deductions, the defense's job becomes exponentially harder. Cross-examining a time-stamped government record is not like cross-examining a witness. You can't shake a document's credibility. You can't imply a log has a grudge. The paper doesn't care who wins. It just is. This is what Kirshner meant when he talked about closing the gap. Every prosecution has to bridge the distance between what they can prove and what they need to prove. In complex cases involving powerful figures, that gap can be substantial. You might have evidence of a speech. You might have evidence of violence, but connecting the person who gave the speech to the violence that followed requires showing something about their mental state. Did they know? Did they intend? Did they deliberately choose a course of action, understanding what might result? Those questions, historically, have been the hardest to answer with certainty. But documented communications about potential violence, created before that violence occurred, fill that gap completely. You're no longer asking jurors to infer what someone was thinking. You're showing them records of what was actually discussed. The intent isn't being guessed at, it's being demonstrated. Lawrence Tribe's commentary on social media has added another dimension worth exploring. He suggested this evidence could shift undecided voters who've been tuning out the legal drama, waiting for something concrete before making up their minds. There's a segment of the population that doesn't follow every twist and turn of these investigations. They hear background noise about court filings and procedural motions, but they tune it out because it all sounds like political theater. Hard evidence, however, breaks through that filter. When you can point to specific documents and say this isn't spin, this isn't interpretation, this is what was actually recorded by federal law enforcement, it reaches people who've been skeptical of both sides. Whether that actually changes voting behavior is impossible to predict, but the potential is clearly there. For people genuinely trying to figure out what happened, documentation beats rhetoric every time. Norm Eisen's analysis focused more on the institutional implications, and this is where things get truly historic. We're potentially looking at legal precedents that will govern how presidential accountability works for the next century. The United States has never successfully prosecuted a sitting president. The legal questions surrounding whether it's even constitutionally permissible have never been definitively resolved. There are Justice Department memos suggesting it can't be done, but memos aren't law. their opinions. This case could force courts to actually decide these questions, to establish binding precedent where currently there's only ambiguity. That's terrifying to some people and exhilarating to others, depending on whether you think presidents should be subject to the same legal consequences as everyone else, or whether you think the demands of the office require some form of immunity. But regardless of your position, the fact that we're even having this conversation is extraordinary. No other modern democracy has grappled with these questions in quite this way. We're in completely uncharted territory, and the decisions made in this case will echo for generations. The presidential dimension adds layers of complexity that would challenge even the most seasoned legal scholars. If this case proceeds to trial while Trump occupies the White House, we're looking at a constitutional puzzle with no clear solution. Who prosecutes a sitting president? How do you impanel an impartial jury when the defendant is the most famous person in the country? What happens if there's a conviction? Does the president continue to serve? Can sentencing proceed? These aren't hypothetical questions anymore. They're practical realities that courts might have to address in the coming months. And the answers will shape not just this presidency, but every presidency that follows. Future occupants of the Oval Office will operate in the shadow of whatever precedent gets established here. They'll know exactly what the limits of presidential vulnerability are because those limits will have been tested and defined. Let's consider what this does to governance in the immediate term. Running the executive branch is already one of the most demanding jobs imaginable. Adding a criminal defense to that workload creates an almost impossible situation. Every meeting with lawyers is time not spent on policy. Every court appearance is a moment when the leader of the free world is focused on personal survival rather than national priorities. Foreign leaders watching this unfold are making calculations about American stability and reliability. Adversaries are looking for opportunities to exploit a distracted administration. The machinery of government doesn't pause just because the person at the top is fighting criminal charges. Decisions still need to be made. Crises still need to be managed. The question of whether someone facing this level of legal jeopardy can effectively discharge the duties of the presidency is not abstract. It's urgent and immediate. Congress will inevitably get pulled into this as well. Some lawmakers will demand impeachment proceedings. Others will rush to defend the president. The legislative agenda, whatever it might be, will get consumed by the gravitational pull of this story. Committee hearings will become forums for debating the evidence. Floor speeches will be about justice and persecution rather than policy. The entire machinery of government will reorient itself around this single case, just as it did during previous investigations, but with even higher stakes because we're past the investigation phase now. This is actual prosecution with actual evidence that actual experts are calling conclusive. The political pressure on every elected official to take a position will be relentless, and every position taken will alienate someone. Here's something that doesn't get enough attention. The international dimension. America has spent decades positioning itself as a model of democratic governance, a country where the rule of law prevails and nobody is above accountability. Our diplomats lecture other nations about corruption and transparency. Our foreign policy is built on the premise that democratic institutions deserve emulation. Watching a sitting American president fight federal criminal charges complicates that narrative enormously. Some international observers will see strength in this, proof that even the most powerful face consequences. Others will see weakness, evidence that our system is chaotic and dysfunctional. Our adversaries will weaponize the footage. Our allies will quietly worry about American reliability. The global perception of American democracy is being shaped by this case in ways that will persist long after the legal questions are resolved. Back to the evidence itself for a moment, because understanding its specific nature helps explain why the expert reaction has been so dramatic. Secret Service communications are generated through a chain of custody that's designed for courtroom durability. These aren't casual observations jotted down informally. They're official records maintained by a federal law enforcement agency that understands the legal significance of its documentation. When a Secret Service log indicates that a particular discussion occurred at a particular time involving particular individuals, challenging that in court requires overcoming a presumption of reliability that's extremely extremely difficult to surmount. Defense attorneys can try to argue that records are being misinterpreted, that the discussions reflected in the logs had innocent explanations, that the context has been stripped away, but they can't plausibly argue the records don't exist or that they're fabricated. The authenticity question, which haunts so much digital evidence, doesn't apply here. These records come pre-authenticated by the agency that created them. The digital paper trail extends beyond formal communications into areas that defense teams historically struggle to explain. Email metadata shows who sent what to whom and when. Server logs show who accessed which documents. The architecture of modern communication creates evidentiary footprints that are almost impossible to erase completely. Even deleted items leave traces. Even encrypted messages have endpoints that can be examined. The idea that a coordinated effort could be hidden entirely from discovery is increasingly implausible in an age where every digital action generates records somewhere. Prosecutors who understand this ecosystem can reconstruct timelines with remarkable precision, building narratives from data points that would have been invisible in earlier eras. This case appears to have benefited enormously from that capability. What might have been unknowable 20 years ago is now laid out in spreadsheets and timelines that tell an unmistakable story. The defense strategy, reading between the lines of what various lawyers have hinted at publicly, will likely center on interpretation rather than denial. When the records exist and can't be disputed, the argument shifts to what the records actually mean. Expect to hear that discussions about potential violence were part of responsible planning, that considering worst-case scenarios is what security professionals do, that foreknowledge of a possibility isn't the same as intent to cause that possibility. These arguments aren't frivolous. In some contexts, they might even be persuasive. Discussing what could go wrong as part of trying to prevent it is entirely reasonable. The challenge for the defense will be demonstrating that prevention was actually the goal. If the discussions acknowledged risks and then proceeded without any visible effort to mitigate them, the responsible planning argument collapses into something that looks more like deliberate indifference. Jurors will want to know, if you knew this might happen, what did you do to stop it? If the answer, supported by the same documentation that showed the foreknowledge, is nothing meaningful, the interpretation defense becomes very difficult to sustain. The term beyond reasonable doubt gets thrown around casually in media coverage, but it matters enormously here. Criminal convictions require unanimity among 12 jurors, that the evidence proves guilt to that high standard. One holdout means a hung jury. One juror who finds the defense interpretation plausible, even if unlikely, can prevent conviction. This is why direct evidence is so prized by prosecutors. It reduces the space for reasonable doubt by replacing inference with documentation. When the evidence is a record rather than a recollection, the doubt has to be about what the record means rather than whether the underlying event occurred. That's a much harder doubt to manufacture. You can't reasonably doubt that a meeting happened if the Secret Service log says it happened and multiple participants have acknowledged it happened. You can only doubt the significance of what was discussed. And if the discussion themselves are documented with enough specificity, even that avenue narrows considerably. Public polling on these issues reveals a fracture that this case will only deepen. Trust in institutions has been declining for decades, but the polarization around the justice system is particularly acute. Large numbers of Americans believe federal law enforcement is politically biased. Large numbers believe exactly the opposite, that the justice system has been too deferential to powerful figures. These beliefs are held with religious intensity on both sides. Evidence that seems conclusive to one group seems fraudulent to another. The same document that reads as a smoking gun in one media ecosystem reads as a deep state fabrication in another. The cognitive frameworks for processing information about this case are so divergent that shared understanding becomes almost impossible. This isn't a problem the legal system can solve. Courts can render verdicts, but they can't manufacture consensus. They can apply the law, but they can't heal the underlying social divisions that make that application so controversial. And yet, the legal system is all we have for resolving questions of individual criminal culpability. There's no alternative mechanism. We either trust courts to do this work, flawed and contested as they may be, or we accept that some people are simply beyond legal accountability. That binary choice is uncomfortable, but it's inescapable. Every society eventually has to decide whether its laws apply to everyone or whether there are exceptions for the sufficiently powerful. This case is forcing that decision out of the realm of abstract principle and into the realm of concrete reality. We're going to find out in the most public way possible whether the American legal system can actually deliver on its foundational promise of equal justice under law when the defendant is currently occupying the highest office in the land. The historians who will eventually write about this era are going to have extraordinary material to work with. The convergence of legal drama, political polarization, institutional stress testing, and technological documentation has created a moment of rare historical density. Almost every dimension of American democracy is being pressure tested simultaneously. The courts, the executive branch, Congress, the media, public opinion, all of these institutions are being asked to process something entirely unprecedented, and they're all processing it differently, reaching different conclusions, operating under different assumptions about basic facts. Whether this ultimately strengthens democratic resilience or exposes fatal vulnerabilities depends entirely on perspective and, to some degree, on outcomes that haven't happened yet. For people trying to make sense of this in real time, the most useful approach might be to focus on process rather than personality. Whatever you think of the defendant, whatever you think of the prosecutors, the question of whether evidence like this should result in legal consequences is fundamentally a question about what kind of system we want to have. If Secret Service records and audio memos and email chains showing foreknowledge of potential violence can't support criminal charges, what would? What would the bar actually be? Conversely, if every politically charged prosecution destroys trust, regardless of evidentiary quality, can the justice system ever function in a polarized environment? These are genuine tensions without easy resolutions. Acknowledging their difficulty doesn't require abandoning your views about this specific case. It just requires recognizing that we're operating in terrain with no map. No one has done this before. No one knows exactly how it plays out. Everyone is improvising. The coming months will bring motions to suppress, motions to dismiss, arguments about privilege, debates about admissibility. The procedural machinery will grind forward regardless of public opinion, as it always does. Evidence will be challenged, rulings will be appealed, timelines will stretch. The gap between what the public knows and what the court considers could widen or narrow depending on what gets released. The media will report every development as potentially decisive. Pundits will declare victory for one side or the other with each incremental ruling. Through it all, the underlying question will remain: can a sitting president be held criminally accountable based on documentary evidence that career prosecutors consider conclusive? The answer, when it finally comes, won't just resolve one case. It will define the boundaries of presidential power and vulnerability for the entire American future. That's not hyperbole. That's just what's actually at stake right now. And every single one of us is watching it happen.